Good morning to everyone. I hope you can hear me. Please let me know if something doesn't function or if you stop hearing me well. My name is Daniela Vrbljanac. I'm an assistant professor here at the Faculty of Law in Rijeka, and I'm one of the team members of the project Train to Enforce, in the course of which this seminar is organized. So today we will proceed with the topic of European Order for Payment and Small Claims Procedure. And I would like to briefly present our speakers for all those who were not able to participate yesterday. So our first speaker will be Judge Martina Arnaitz from District Court for Commercial Matters in Vienna, and Attorney at Law Dr. Maria Shkov from law firm Grilz Vogt Shkov. The presentation of Associate Professor Philip Anzenberger from University of Graz will follow. University of Graz is also one of the partnering institutions. And yesterday we had the pleasure of hearing the presentation of Assistant Eva Wolkerstorfer. So I will not bore you with my introduction. I would just like to invite all participants to pose questions and comments either in chat or orally. And now I will give the floor to our first speakers.
So good morning from us. I'm the head of the District Court, Martina Arnaitz. I'm the head of the District Court for Commercial Matters in Vienna. Our court is the central court for the European Payment Order in Austria, as I told yesterday. And we do 5,000 payment orders per year.
Okay, my name is Maria Shkov. Hello to everybody who is attending this training session. I'm attorney at law admitted to the Austrian bar and to the Slovenian bar. And in our law office, we are known and we are famous in the region for our cross-border expertise. 95% of our cases are cross-border cases, so we have a lot to do and a lot of experience with enforcement cross-border, claims cross-border. So we are representing many Austrian companies which are working either in Slovenia, Croatia, and other ex-Yugoslavian countries, and the other way around, namely individuals as well as companies coming from Croatia, Slovenia, Serbia, Bosnia as well, and working towards Austria. So we are really kind of cross-border lawyers, and I'm pleased that I can and we will just start with our training session, because yesterday there was the general lecture as well on the European payment order, so what the legal background is and what the provisions are. And with Martina, we are going to share with you the practical insights, how to deal with this question, how to start an European payment order procedure, and what you have to pay attention to, and what are the crucial aspects in practice to this question.
So yesterday we gave you homework, so that's why I think we lost so much of the audience. But now we try to look at the form with you together.
The application, if you had a chance to look, I mean, we are not going to grade anybody, so it was a bit of a joke and a bit, of course, seriously. If you had a chance to look in the application for the European payment order, and we thought it might be a good idea to go through it. You've got the application, the Form A, in your handout, in your materials, and we thought it would be a good idea to go through step by step because at the end of the day, you need to fill it in. And I have to confess from my experience, it's sometimes it's really difficult to read because it's very, very small print. And if you are not paying a lot of attention to, you just skip a line and then you can get the requests for additional questions and an improvement and so on. So that's where we thought it should be, it's a good idea to go through it, through the form. And we hope, of course, that this will help with your work.
And we start how we find out the right court. There's a link you see now. We hope you see it now.
These useful links, which we included in our materials, I think are quite interesting and quite good, where you can really find a lot of information. As well, there is a practical guide on the European payment order, and okay, we apparently we are not the really the best experts in technical questions. That's the file.
Yeah,
That's the form.
The form. Yeah.
The question, which is that?
How you find the right court. There's a link on this homepage for finding the court too, where just put in the zip code, and for each country, and for each country you will find the right court. For all of Austria, it's the District Court for Commercial Affairs. For Germany, it's one central court too. It's the Amtsgericht Wedding in Berlin.
For instance, in Slovenia, you don't have a central court, but you have to send it to different courts. So you don't have a centralized procedure, but you have different courts, and you have to send your application to one of these courts or to the court which is competent. So in Slovenia, for instance, it's the Višje sodišče, and they are okrožno sodišče. They are the competent courts in these procedures, and you have to apply there. For instance, in Hungary, it's the public notary who is the competent one for these procedures. So it's important to check in the beginning what is the competent court, and the homepage works really well. If you enter the address or the zip code of the respondent, you will get the correct information, which is the correct court where you have to file your application.
So we start with the Form E. Now we found a court. The parties and representatives. The form works a lot with codes. The best what you can do is just use the codes. And for example, claimant is code 01. Yeah.
You can see here in the top line, it's written two parties, and underneath it's written code 01, 02, 03, 04, 05, and 06. I know we lawyers, we are used to read very quickly, and sometimes we should pay attention to all the small prints, and we don't pay that much attention, and then errors are coming up. But that's exactly the codes which you should use. In the first field you put, for instance, 01 for the claimant, 02 for the defendant, and so on. So that's how this formula works. And again, you put the informations or the details of the claimant, of its representative, and you put as well if the claimant has a representative, a legal representative, and the same goes for the respondent. you put the details, and the same. I mean, usually in the beginning, they wouldn't have a representative. That's why probably just put the details of the
And you
claimant.
don't know the claimant's representative, for example, or the defendant's representative. The main and the most important are the claimant and the defendant.
And again, what we said yesterday, try to provide full details as much as you can, because it makes work so much easier, especially if there are questions from the court. They can also contact you and ask for additional specification, and this makes things much easier and less bureaucratic.
Then point 3, we have grounds for the court's jurisdiction. There are codes too. You have to check Brussels 1, which one you need jurisdiction in the country you want to make your payment order. And here, for example, we have, I don't know if you remember, we were skiing in Austria and we have our designer snowsuit. And we are consumers, so we just take code 08, domicile of the consumer. And you don't have specifications you only need for code 14 other, but in general you have all points you need in these codes.
So point 3 of this form respects actually Brussels A1, as we did yesterday. You remember we just briefly went through, and I mentioned that probably the most important place of jurisdiction is the place of the domicile of the respondent. One, and secondly, for sales contracts, the place where the goods should have been delivered or were delivered, and the third place probably where the services were delivered or should have been delivered. So I think this is probably the most important, or many jurisdictional places or many forums are covered by these two provisions, and accordingly you just put then the code, you choose the code 01, 01 and 02, and that's actually it. And I think it's important to know with this form, use only codes. It's not, because at the end we will see you can convert it into another language, and anything which you put into the formula, words, explanations, and so words, it's getting complicated, because then the formula is not really translated entirely, and you might have problems. We'll touch upon this later on. So that's why it's important to know that this is just a form where you simply use codes.
In Austria, we have an IT application where we can just translate these forms. So you can serve it, for example, in English or in Croatian, and the more words you use in your language, or the more German words you use, you need a translator, yeah?
The more complicated it gets, because the other person is not understanding it. Again, in the case of the European payment order, you have to indicate the cross-border nature of the case, again, by indicating and choosing the proper code. So if this is a case between a Croatian company and a German company, you use the codes, and you put the codes where in the first field the domicile or habitual residence of the claimant. So if this would be a Croatian company, you put the code 09 in the first field, and in the second one, if this was an Austrian, you would put the code Austria 19, and that's it.
Yeah, and as we yesterday heard from Eva, there could be, for example, Germany, you can have domicile or habitual resident of the claimant, could be the same of the domicile of or habitual residence of the defendant, when the country of the court is another one. Yeah, then it's cross-border too.
The next point is the bank details. I referred to this yesterday. The question how you're going to pay the court fees, it's important. I indicated yesterday when we were talking about a small claim procedure, I told you the story when we requested this payment order in Venice, and the judge from Venice contacted our law office stating that we have to come there and to put the stamps personally on the European payment order, which is absolutely contrary to the purpose. Now, as you see, you can also pay by either bank transfer, credit card, and other means, and this works pretty well.
Yeah, and as you see now, 04, you can ask for legal aid too, so you don't have to pay court fees.
Maybe this is an interesting question which we should touch upon, the legal aid question. Legal aid in Austria can be requested by anybody who does not have the means for, or who cannot afford the attorneys and the court fees and so on. But in order to get this legal aid granted, you have to disclose, of course, to the court your situation, your financial situation, how much you earn, whether you have a property, whether you have loans, and all these things. And the legal aid goes also for especially in physical persons from abroad, so from the European Union, not from abroad, not from third countries, but from the European Union. So anybody who is a citizen of the European Union can, if he has got a claim and a bad financial situation, cannot afford the costs to defend himself in a legal procedure, may request as well for legal aid.
So, point 6, principle. We have codes here too. You have sales contract.
In the point 6, you actually have to define what is the basis of your claim. So is this a sales contract? Is this a rental agreement? Is this a contract for services or anything else? And all these different legal grounds are again attributed to specific codes. So if your claim is based on a sales contract, you wouldn't put there and you wouldn't write, okay, on the sales contract dated and so on, but you simply put the code 01. If this is, for instance, a claim which is related to, I don't know, to an insurance contract or a loan contract, you put the codes for the loan, let's say code number 15. And so on.
That's all you do.
And that's all what you do. So this is very different from our legal work usually, where we tend to write books. I mean, the submissions we usually write and we try to provide the court with as much details as we deem necessary. Of course, we are not providing everything, but we are providing what we deem necessary, and we tell the story. Whereas this is a formula where you simply put the code, you just put, okay, my claim is based on a sales contract, it's based on 01. So this is really actually very different from our traditional lawyers and legal work.
The currency you have in front, you have here, you just write down what the sum of what you want, 2,000 euro, 5,000 euro, whatever. And the IDs in the beginning here, ID 1, just mean if you have more, not only one thing you want. If you have, I don't know, 2,000 from a sales contract and 3,000 of a rental agreement, you write ID 1, code 01, 2000, you write ID 2, code 07, 3000.
But of course, you have to have these claims against the same defendant. So if you have different claims, arising from the different legal grounds against the same defendant, then you can use the same formula for the procedure.
Yeah. Code 2 are circumstances invoked. You have non-payment, I would say, or insufficient payment, or you write code 30 or code 31 in here.
You see, in the first, we were talking about the legal grounds, and then we were talking about the circumstance. What is the reason? Because you have to give the reasoning. And the reasoning is, as well in this case, you just simply provide codes. Non-payment is 30, 31 is insufficient payment, 32 is late payment, 33 is non-delivery of goods or services, non-delivery of or delivery of defective good or poor services, and so on. And again, you put the code. You put the code in the column of number 2, you put the code, I don't know, 30 for non-payment or defectious good or whatever. So this is really very different. And then you have the column 3, where you can put other details, which is not really...
It's a little bit complicated. Yeah, I don't know. You can just leave it with code 3, because sometimes you don't know what to write down. If you have a sales contract, non-payment, you write a sales contract code 1, non-payment, code 30, but why would you write place of purchase, date of delivery? Yeah,
actually, in practice, we have not understood.
Nobody
has understood
this
so
code 3.
far what is meant by other details by code 3. So if just leave it, I think it's not really a problem if you don't fill it in.
Yeah.
And then you have here in the bottom of this page number 3, you have to indicate whether your claim concerns a matter relating to consumer's contract, yes or no. And you tick, if it's a consumer contract, you tick yes. If it's not a consumer's contract, you tick no. That's it.
But you have to fill out all these 3. It depends. Yeah. If you write down the claim contains matters relating to consumer contracts and you say no, then you are ready. But if you say yes, you have to take the second one. If yes, the defendant is the consumer. And if you now fill in yes, what is your problem if the defendant is the consumer? Then you have problem with the jurisdiction, because that's are many mistakes in this point. Because you can, if the defendant is the consumer, you can. There's Article 6 of the regulation, and it's not possible to. You need to have this application for European order for payment in the domicile country of the consumer. Yeah, and if you say no, if you say yes, then you have to go to the third one. If yes, the defendant is domiciled within the meaning of Article 59. It's really, really simple. Yeah, you just have to read the form and the regulation.
Yeah, but the problem with reading is that this form is really very small printed, and it's sometimes just not so easy to fill it in. The next point, which is an interesting point, a very interesting point, is the question of interest. Because you, of course, you have to request, if you want the court that the court is going to award you as well the payment of interest, you have to ask for them. And again, you are asking for the interest by applying codes. So code 01 you would apply if you would claim statutory interest. 02 if you would claim contractual interest, and so on. So you just simply put the code, and then the program, I mean, in the case of statutory, or should the program work for you, whereas in the case of contractual obligation, if you put 02, you need to put the interest rate, how many percent, and again, just put the figure, either it's 8% or whatever. So
And you have to take care, if you have a statutory, you have to write down not only 01, with a 01, you have to write down 01A per year or 01B per half year or per quarter. Yeah? Because if you forget it, maybe they will send it back and ask you, what do you think? What interest do you want?
And then important, of course, you need to determine the amount from which you want to have the interest, and then from when on you want to have the interest until when. This is something which I learned a lot, but we will touch upon this afternoon when it will go to the enforcement, when I'm receiving Croatian certificates from the courts that the due date is not precisely indicated. It is fundamental that you really indicate the due date and the date from which on the court or the interests are due. Because if it's not indicated, you cannot calculate them. Nobody will do the work for you and decide for you from which moment on you want to have you are entitled for this interest. The issue is, as I said, I will touch upon this in the afternoon when we come to the enforcement, especially when we have the direct enforcement. This has nothing to do, is really, or maybe as well, with the loans. When we have the direct enforceability of notarial deeds, especially Croatian notarial deeds, I saw very often that it is not clear from the notarial deed which is directly enforceable, actually from which moment on it's directly enforceable and which interests have to be paid. But we will touch upon this question this afternoon when we talk about enforcement. It's just a bite and a teaser for this afternoon.
Yeah, so point 8, if you have your contractual penalties, you write it down, but it's not very often, I would say. Point 9, costs. Code 01 are court fees. You don't, I mean, if you're from abroad, you don't know what the court fees in Austria or Croatia are, but if you just have to write down code 01, and the court himself would put in the court fees. Yeah, it's enough if you write down the court fees, but within the court fees there are only the fees for the court. Yeah, the lawyer's fee is not in this cost, and sometimes there are difficulties because in different countries it's all mixed up. So if you want lawyer's fees, you have to put down code 02 and write down lawyer's fees, or I don't know, cost of the lawyer or whatever costs you had.
Maybe I can just add some practical aspect. Indeed, I mean, Austrian court fees we know, but as you're never sure what the court will then award you, so you just simply put the currency, but you wouldn't put the amount. But with respect, for instance, to the lawyer fees, it's really questionable which amount are you asking, because in Austria for lawyers, the lawyer's fee, especially if it comes to court procedures, they are provided for in a specific law, which is the law on the fees of the lawyers and attorneys, and basically we are all obliged to work on the basis of this law and the fees which are provided and stipulated in this act. And that's, for instance, when I'm asking, I'm usually putting two different requests. The one is the court fee, and the second one is the fee for the lawyers. But maybe you can say something about how the court deals these requests, because if I'm putting a European payment order in Croatia or Croatian attorney in Austria, would you award the Austrian fees or would you award the Croatian fees?
We can't in a certain. Yeah, we judges in Austria have no idea about Croatian lawyers' fees and about Italian lawyers' fees. So in a certain way, we just look if it's okay, and we wait for opposition. Yeah.
Probably lower than Austrian.
So yeah, we look at the Austrian fees and we say okay, it's yeah. and we look at the amount, because if you want to have 2,000 euros and the lawyer's fees are 10,000 euros, you would send it back and said, what's that? Yeah. But if
Please
it's
specify.
yeah, if it's in a certain relation, you say it's okay. You don't, yeah, you won't ask for it.
If it's kind of proportionate. But for instance, it was mentioned that, of course, the Croatian fee and the law which provides for the fees of the attorneys is lower than the Austrian one. The Italian, for instance, is much higher than the Austrian one. The Italian is just incredibly high because they have an additional fee and a lump sum for, I don't know, and it's quite high. So we have really different standards in Europe. But one question which I would be interested in, many lawyers, they have the fee arrangement with the clients, and they are working on an hourly basis. So if they would just request the compensation on an hourly basis?
I don't think so. I think that if we would really look at it, it's the court's law and it's Austrian law on which based we should give the lawyer's fees. Okay. I think we had to find out the Austrian.
All right. Then, of course, it's additional aspect which you have to provide, or additional materials, which are the evidence available in support of the claim. And again, you choose the codes. You're not putting there, I don't know, contract dated from this and so on, but you use the codes. Of course, you use simply the codes. As we said in the beginning, or as Martina said in the beginning, write as less as possible, not as much as possible, but write as less as possible, and just simply use figures, because figures, when translated, remain figures. So that's why use as well, like, of course, you can provide for witness evidence, oral evidence, but it depends. If it's really opposed, then might be interesting. But
yeah, but you could write O2 and you write the name of the witness, so you don't have to translate it, you know,
because names are not translated.
Or you write written evidence and you write the number of the factura, and then you don't have to translate it. Yeah.
Do you have to put it with the...
No. It's better.
Which evidence?
Yeah, you just write down what evidence, and please don't put any other things with it. Yeah.
For instance, if you have an invoice, I mean, if I'm, for instance, claiming on the basis of an invoice, I would never write invoice or Rechnung in German, but I would try to find a word which is international for invoice, or which might be the same in other countries. So I would, even though it's not so much used in German, but I would write Faktura, which is in many, it's understood in many countries. So I would choose words which are, let's say, more international than the typical Austrian words or German words, like Rechnung, for instance.
So, and as you said in point 11, you better write nothing. Yeah, lawyers are used to write their everything.
But there is a lot of space. In point number 11, you have really the space and the place where you could.
Yeah, the problem
prove to the court that you are a good lawyer, and you have.
You prove it to your
and to your client.
How good. Now the problem is really the applications have to be in German. Yeah, but if we get it in German, our IT application can translate it into Croatian, into Slovenian, into Italian. Then we had, together with the Amtsgericht Wedding, because this application is together from Austria and Germany with the Amtsgericht Wedding, we have lists for words in all European languages, so we can translate ourselves Rechnung, Faktura, but if you have, I don't know, a site full, you can't translate it, and it's costs, you know, because we have the regulation for the service of documents, we have to send
That's
it
the
to Europe. We
aspect.
have to send it to Europe. At first we tried without translation, but if it is rejected, you have to translate it. Yeah, then you have translation costs. The translation costs are not in the European order for payment. They are special costs. You have to do another
Request.
request. The other request has to be translated too, and you do it for the rest of your judicial life, you know. So it's better just to have these form in the right language. Yeah.
The issue is because the respondent, if he receives or he's served this European payment order in a language which he's not able to understand, he can reject. And this means that you actually have never submitted, or he's never became party to the claim. So, and this is actually the problem why we are saying, don't provide so many information, use really the codes which are kind of international use figures, because so you can avoid the problem with serving. Because as I said, if I am served or handed in a document which is not in my language, which I cannot understand on the basis of the European regulation, I can just simply reject it, and it's going to be the claimant's problem how he will deal with the problem that I will really become a party to the court procedure. So that's the reason why we also point out it makes no sense to put that many. It's not just for fun, but there is a legal reasoning behind why we would not suggest to do so.
Yeah, and the problem is if it's not, if the total value is small, you don't want to have a lot of translation costs, because in a point, it's not useful to do these European order for payment at all.
So the next aspect again relates to the payment. Again, you indicate whether you want to pay by credit card, the collection by court from the claimant's bank account. So this became, we indicated or we discussed about this several times in the last days. This became really common to pay court fees as well by credit card or by credit card. In Austria, it's like this, that we lawyers or attorneys who are admitted to the bar, we grant the court the access to our bank account, and the court simply deducts the court fees from our bank account, whether we want it or not. So in the moment when we file the claim, immediately the court fee is deducted from our bank account. So which means that I have to make sure that the court fee has already been paid. I mean, if this is a small amount, it's not a big problem. But if the claims are for a big value and the court fee could be, I don't know, we had a claim which was really a very important one, and the court fee was more than €1 million. So it was really important to have the money on our bank account because before lodging the claim, because otherwise we would have gone bankrupt because we could not pay the court fee. Or the court would take everything, and and consequently we wouldn't be able anymore to maybe pay other.
About Appendix 2, Eva spoke to yesterday. It was changed since 2009, and I think they make it even more complicated. These Appendix 2 you have to read really, really good, because with these codes you get a little bit dizzy.
Appendix 2 actually relates to the question if the opponent opposes to your payment order, what do you want to do? Whether you want that the procedure is going to be stopped or not, what do you want to do? This is actually the question behind, and then you have to answer what you actually want. So and
the question, if the defendant lodges a statement of opposition, I request that the proceeding discontinue is a very special thing for our civil procedure, because someone says in the beginning, if I get an opposition, I will stop. You know, in Austria, you have to stop it then. You can't say, if there's an opposition, I won't go further. But why don't you think, why did they invent this?
This is actually completely unclear, because usually, I mean, if there is the opposition, then you would go into a normal procedure like it is normal in all countries, because at the end you wanna, it's not just that you are filing this just for fun, but it's just because, I don't know, you at the end you wanna have a title, an award on the basis of which you can enforce.
That's what lawyers says, but yeah, but I would say it's a cross-border procedure. Yeah, I think they want to make an instrument. You can try it. If you have smaller claims, you just try. If I want to have 500 euros from someone in Poland, yeah, I can try it. I do this payment order, but if he's doing an opposition in Poland, I just say no. I don't want to go to Poland and have a proceeding there. That's, I think, is what's the meaning of all these?
To give the
Because
claimants
they
the
won't,
chance, or what?
No, because the defendant won't get these appendix 2. Yeah, the appendix 2 is not going to the defendant. Yeah, they don't know if I do an opposition, it stops. That's not the part which is going with the payment order. You know, it's just a try, because in Austria I would say 15% is opposition. Yeah, and so you can do smaller amounts, just try it and then stop it. Because I don't know, no one wants to have, I don't know, proceedings in Romania for 200 euros, for example. Yeah?
And I just simply take an economic decision. Debtor.
Yeah.
It's too many costs to pay a lawyer, to pay court fee, and because notary here makes the first decision.
Yeah.
If because it's the court and people, if it is some small amount,
They don't want to go. Yeah, I think that's the meaning of this. Yeah. And in the beginning, when this procedure was invented, many lawyers didn't look what they were doing, and they were just crossing it, but it was wrong. But then it was over. Yeah, for them.
So they choose to discontinue.
Continue, but they didn't want to discontinue.
They wanted to continue.
But
okay.
the court said,
Sorry.
I'm very sorry, you've chosen this appendix 2, so goodbye. But he can do another payment order, of course. But he lost the court fees. You know?
But you can still, if you want to continue, you can still stop if you don't want to go on.
Yeah.
You still have the other way around. You have the possibility to do so. Okay.
And then you have, that's a new, you can choose if you want to go, if you continue the proceeding with the small claims procedure.
So you can switch from one procedure to the other. They are quite interflexible among themselves.
Yeah. No. Then you are after the form C. Yeah. you're starting with a written procedure or whatever.
But what about the competent court? In the small claim procedure, we learned yesterday that, for instance, in Austria, there are different courts which are the competent court, whereas in the European payment order, there is only one court, which is the court in your court in Vienna. If the party chooses to continue with the small claim procedure, what does this mean for the court for the competent court, for the forum?
We we send these. When there's opposition, we ask the claimant which is the right court, which is and then we send all the procedure to this court.
Okay.
It will go to another court to Austria. We just do the work till the opposition, I would say. Yeah.
Okay, and this goes also for the small claim
Claim
procedure,
procedure.
which is then actually the.
Yeah. Sometimes we are the court. For Vienna, for example, when if not, we send it all over Austria.
So you prepare a nice parcel and
Yeah,
send everything,
go, yeah.
mail everything
Yeah, yeah.
to this competent court. And very important at the end, the signature. It's maybe it sounds ridiculous to you that I'm indicating that you need to sign. You really need to sign because it's normal, of course, that you are signing forms. But in my view, as the forms, they are not really very clear. You could simply forget about it, that you just sign it. So think about it, that you really have to sign it and to stamp it. And you have to sign and stamp it 2 times on page 5. It's different. You have 2 signatures. One is on page 5. And then on page,
And then the appendix.
and the appendix, you sign another
sign
time.
it. Yeah.
So make sure you have 2 signatures. It already happened to me. I thought I just signed the appendix because I didn't read correctly. And then it turned out that I had to sign as well the application. But it's a bit confusing. The form and the application is really a bit confusing. That's why I'm indicating. So make sure that you're really signing on page 5. On page 5, yeah, where's the end of the request, and then the appendix in addition. Okay.
Are there any questions to the form? From
Is there any suggestions, any questions? I hope this is useful for you when you were trying for, oh, wonderful, somebody
Yeah,
joined us.
yeah, good
Yes,
morning.
please. Hi.
I yeah, thank you. I have a question because I work as a lawyer in Croatia, but I'm also niedergelassene Rechtsanwältin bei der
Ja.
Rechtsanwaltskammer Wien. And now I have a question. What does it mean to stamp? Do I
you
have
don't have to stamp.
Yeah, yeah, because I have Croatian stamp, but I don't have
You
Austrian
don't have
stamp.
to stamp. You just have to sign.
Okay, fine. And can I send this kind of formula also electronic or only
If
per
you
post?
are Austrian lawyer, you can send it electronic.
Okay.
Because you are on this
Yeah.
ERV. If
Yeah,
not, I
it's
would
been-
send it by postal service. Yeah?
Okay. Thank you very much. Okay, my question was actually regarding stamping because that wasn't clear to me. Thank you very much.
Maybe because the question was whether you can send it electronically. We as Austrian lawyers, we are connected with the Austrian courts with this electronic program, and we are using, of course, this program in Austria. But as soon as we are bringing claims, I don't know, in any other European country, I don't know, in Germany, at the Amtsgericht in Wedding, or in Lithuania, in Slovenia, wherever, we just simply print it out and use the postal service. But of course, we use we send it by registered mail, not by ordinary mail.
And Austrian courts don't take emails. As emails is
not accepted.
An email is not accepted. It's sent back but they're trying to enforce these electronic forms, but it's not really working good, I would say, from abroad. Right.
Thank you for your comment and your question. Thank you.
Yeah, thank you too.
Okay. I think we have prepared a couple of questions for you, and which are related to aspects in relation to the European payment order. And we thought we would just go through these questions because maybe you will get some interesting inputs for these procedures when you will launch them. The first question, thank you. Thank you so much. The first question, I will read the question and we may discuss, because we already had the discussion on this question when we were coming to Rijeka together. The first question is, does an application for the European payment order interrupt the claimant's limitation period? Of course, it's very important, because as soon as I lodge a claim, it's under national law, it's the general principle that the limitation periods are interrupted, which is fundamental, because if you really get to lodge it on the last day of the limitation period, you are safe. If not, you just simply had a lot of work and that's it. So,
but yeah, I would say it interrupts the limitation period, because it's like a national procedure. Yeah, it's an European procedure in Europe, and I would say yes. Maria wasn't.
I was not sure. We had the discussion and I said, yes, okay, I agree if you say it interrupts. But what if I'm simply not, I'm choosing discontinue in the appendix 2 so that I don't want to go on with this procedure. Why should this interrupt? So this was a nice try. You didn't go on with the procedure. So I was of the opinion that it should interrupt in the case that you really, or that the claimant continues with the procedure, with the court procedure as an ordinary procedure, whereas I was of the opinion that it should not interrupt it when it wouldn't go on. Yeah, but as I said, there is no European, we discussed yesterday in the evening, and we said maybe this might be a question which we should put to the European Court of Justice as a preliminary ruling, how to deal with this question.
Yeah, but the question is, if you do an application for European payment order on the last day for the limitation, I would say, yeah, it's enough. Yeah, but maybe you should do it a little bit earlier.
It's always bad to put to file claims the last day of the limitation period, but yeah, there is, as far as we know, there is no no preliminary ruling on this question. So maybe this is really an interesting aspect to be clarified in future by court practice or whatever, or maybe it will be decided in different ways as well in the European member states. So it's
yeah, but my meaning is it's like a national proceeding, so it has to interrupt the limitation period. But
as you see, it's the same in Austria. 2 lawyers, 3 different opinions, and yeah, I'm sure this is the same in Croatia. Okay. But I mean, nevertheless, you know, as lawyers, it's not wise to wait for the last day to have claims, even though I know that clients are they are hesitating to file procedures, and then at the end they are coming, we need to do something immediately, and yeah. All right. Is it possible to conduct a procedure solely in writing if the defendant lodges a statement of opposition? This question relates, I mean, yesterday when we were talking about the small claim procedure, the small claim procedure is a purely written procedure, whereas the European payment order is different.
Yeah, it depends if it's possible to switch to a small claimants procedure. If you switch to a small claimants procedure, you can do a written procedure. If not, if you have a national procedure, it is not possible, not under Austrian law, to just make a written procedure.
The Austrian civil procedure the law on civil procedure doesn't provide for any written procedure
when there's an opposition.
Exactly. So which means that there will be an ordinary hearing conducted at the court, which is the competent one, a classical court procedure with the examinations of witnesses, maybe with witness statements, examination of witnesses, expert witnesses, and the proofs like you and we are all used from our traditional court procedures.
Can negotiation be held by means of a video conference? That's the same. If you are in a small claims procedure, you can you can make hearing by video conferences. In Austria, we have video conferences in Austria, a lot of video conferences, but these are made like this, that the lawyers and the court is in one place, and the witness maybe is in another place. At a small claims procedure, you can just make hearings like this, that the court is in Vienna, the defendant is in Poland, and I don't know, the claimant is in Graz, maybe, and you can make you can make really hearings by video conference. Now in the COVID crisis, the Austrian civil procedure allowed Zoom conferences. It's a little bit like this. We had it, and we had it in our civil procedure, and it was used, I would say, a lot over the COVID period. Now they want to switch it in the national civil procedure. We will see. Asked in our ministry how many video procedures we have, and we had, for example, 2020, 280 Zoom conferences and 500 abroad, but 7,000 video conferences in Austrian video conferences, where witnesses were interrogated in Austria. Yeah, but it was half of them, maybe 2019, and it's used.
I would like to add an Austrian Supreme Court decision, which, however, it relates to video conferencing, but to arbitration. But I think it's still interesting to see maybe where the practice will go, or how the courts and the Supreme Court especially will deal with this question. And in the Austrian, this was the first decision on video conferencing. As I said, it was in arbitration. It was okay that the right to be heard and the fair trial principle, which is as well fundamental either in arbitration or in civil proceedings, was not that it was in line with the principle of fair trial if the video conference, if they would conduct hearings by video conferences, and even if there was a big time difference. So there was the case, the one was sitting in America and the other one was sitting, I think, somewhere in Asia. So there was really a big difference in this time, in the hours, and the Austrian Supreme Court said, no, it's okay. Even though the one had to get up at 4 in the morning and the other one was witnessing in the evening, the Austrian Supreme Court said this is okay, and the right to be heard and interfered with. So this is a very interesting aspect, I think. So probably it will also getting more used and more used in ordinary civil procedure, especially if it comes to the first hearing, where actually you just decide the program of the procedure
with two lawyers,
usually with two lawyers, and it makes no sense to go there to make a lot of kilometers just to go there to decide a procedure and then to go back home. It's probably more cost convenient if this would be conducted in future by video conference. But then,
But I said,
but
the chance for getting a settlement is not so good if the people sit somewhere on a screen, and if you're not in a courtroom. Are there any remarks on video conferences, Zoom conferences?
do you have any experiences in Croatia with video conferences and hearings during the pandemic? Did the courts use this tool for
Yes, I have experience with commercial court. Quite well, and it was a have any witnesses in the trial. It's a criminal perspective. So now to bring so they can stay there. I personally don't like because I prefer to have my it works well.
So we just got apparently also in Croatia during the pandemic, video conferencing was a tool which was used in civil procedures and as well in criminal procedures in order to avoid that the prisoners would mix up too much, but they would rather prefer that they would stay in prison and that they would testify from the prison. So this is very interesting. Apparently, it's really a tool. We have to get used to it, and I think it has its advantages, definitely. All right, so let's switch to the next question.
Yeah, you have requested an European order for payment. After it was sent to the defendant, you realized that the claim does not fall within the scope of Article 2 of the regulation. What could you do? The question is, what could you do as a judge? Not as the defendant.
When I was preparing these questions and I was going through, I said, what would you do? I wouldn't do anything. I would simply wait as a lawyer whether the judge would understand this, and if I would get the payment order, I would say, okay, nice, it was good. If not, I would say, okay, nice, try once again. But of course, it's from the judge's perspective.
Yeah, but from the judge's perspective, really, you can't do anything. You just wait what a defendant does. You can't just say my European payment order is now. Yeah, you wait. The defendant can do Article 20 procedure, or they can ask for Article 20 of the European Payment Regulation. But judges, yeah, they have to sit and wait.
It's still a party-driven. It's a civil procedure, which means it's party-driven, so it's not that much court-driven.
And it's not in the regulation. If you read Article 20, it's always the defendant can ask for. It's not saying the judge, if the judge finds out it's he can do it von Amts wegen, as it's called in Germany. Was it? Ex officio. Yeah.
So this means as well, if you're the defendant, you have to pay attention. It's not just a matter of making an opposition, to file an opposition, but also to pay attention whether it's correct or not correct and to act accordingly.
Yeah, and you have this review in exceptional cases, and I would say if the defendant does this Article 20 review, he will succeed.
What about the cost if he would succeed with such a review? Would they be awarded?
Maybe there was a Amtshaftung. Maybe he will get the cost from the Republic because it was a responsibility of the judge, because it was a mistake of the judge. It could be.
Mm-hmm.
Sorry. The question 5 we answered yet, so we can just
skip it. We go straight to answer 6, to question 6. Which regulations are additionally applicable to the service of the European order for payment? Are there any other regulations which you have to consider in relation to the European payment order regulation? There is this regulation we talked about yesterday, So the question is, are there additionally regulations which might be considered? We touched upon already one, which is Brussels A1A, of course, which is related to the jurisdictions, maybe as well Rome, because if we have to talk about the substantive law and which substantive law is applicable, okay.
And we have, of course, the Article 13 and 14 of the regulation itself. Yeah. And the problem with these European regulation is this, there's the services in each regulation a little bit different. So, yeah. So for the European payment order, you have to look at the European payment order, and then you have to look at the European order for the service of documents. So, and you have to know in a certain way all national laws, all national service laws, because we don't know how in Poland the postal service works. Yeah.
Maybe I think it's important to know if it's the European regulation on the service of documents, which is the regulation 2020 through 1784. It's the one which provides for the basic principle on the European level for the service of documents. There is one very, very important provision in this from the defendant's view in this regulation, which gives the respondent the right to reject documents if it's not in the language in which if he has not been informed about his right that he can reject. And the defendant has a period now so far for 8 days within which he has the right to think over whether he wants to accept or not. This period is going to be extended to 2 weeks, so which means that the defendant has the right to consider, reconsider, whatever, and to decide whether he wants to accept this writing or he doesn't want to accept this writing, because once he accepted this writing, it means that the writing was handed in and then the procedure starts actually. So, but he has this grace period, and this is actually very important as well in relation between Croatia, Austria, Slovenia, and Austria, because there is this enforcement on the basis of an invoice, which is very common. And there is for instance, in Slovenia, there's a very short period within which it's within 8 days where the respondent can oppose. So basically, if we consider this European directive on the services, the period to oppose under national law is the same as the period under European law, where the defendant has the right to consider whether he wants to accept or he doesn't want to accept. And there is currently a procedure pending at the European Court of Justice. It's C7 through 21. It's a very interesting question exactly related to this, whether how long the opposition period must be, how it's considered with this grace period and so on. And it's interesting also because it was an Austrian court who filed to the European Court of Justice a preliminary ruling which relates to the Slovenian legal system. It's relating to the izvršba na osnovi verodostojne listine, or in Croatian, ovrha na verodostojne listine. So I think this will be a very interesting preliminary ruling related to this cross-border relations and to this grace period. And how to deal with the acceptance, non-acceptance, and so on. And I mean, in this period, maybe just some additional insights. There is also the European Commission already provided its statements in this procedure and stating that that of course the opposition period is not the same as the grace period, where you have to consider and to think of if you want to accept or not accept. And in addition, the European Commission said that 8 days is too less in an international or cross-border relation, not international, but cross-border relation. So we'll see what the as European Court will say afterwards, but maybe an interesting ruling, which could be interesting as well for Croatia.
And that's why it's so important just to use the codes. So you can translate the form and you don't need any, if someone in Italy is sent an Italian payment order, he has 30 days to oppose. Yeah. That's why you should really use the codes and don't I don't know,
Don't write
stories in
field
11. In field 11.
Don't write invoice, don't write invoice, but write factura, because factura is used everywhere. So yeah, all right. Okay, let's go to the next case. The next question: can a European order for payment be served by means of an international registered letter with acknowledgement of receipt? This is a typical question for a judge.
Yeah, and I would say yes. It's Article 13 of the European Payment Order Regulation, so it is possible. Yeah. If someone, we have a lot of international registered letters now. We send all over Europe, and you just have to trust that there may be that you don't know if the CEO has signed. But I think it's enough if the portier if the secretary signed, yeah, and if you have a international registered letter where you have a date and to sign, it's okay. Sometimes there's no date, but it's useless to go to a post office to Romania and ask them when did you when did you hand this letter out. So we just write down when today, maybe when it's the 1st October, I write down it is served at lately on the 1st of at the latest on the 1st October. I wait 30 days, and if there's no opposition, I would say it's okay. Yeah.
Mm-hmm. I mean, in former times it was uncommon that writings were served with the registered mail, but today it became really common that they are simply just serving and handing in with registered mail all over Europe. Any questions? If not, we will just go on. Can an European order for payment be based by means of an international register? We already answered this question.
You receive an Italian acknowledgement of receipt regarding the service of a European order for payment from Italian service authority. And you cannot speak Italian, that's the problem, yeah? I think the biggest problem in our work with our payment orders is the service. And we sometimes realize just like, you have to speak different languages and you don't know, is it served, is it not served? If you need an interpreter or a translator, the question is who will paying the translator? And so we just try to find someone who speaks this language and ask this judge or this practitioner, is it served or not? Yeah. There are forms in this regulation of the service of documents too, but many, for example, the Italians use the forms and then they send us 3 pages of Italian, I don't know, explanations, and you don't know what did they write down.
This is a really, I mean, these means are very interesting in the European field, but it's really still a question of the language, because we have 27 official languages in the European Union, and it's difficult because of course they are not the same. So maybe it would be wise if they could change these procedures, which are European to English. I know this is a very delicate request, but it would facilitate the work, because I think in Europe we are all talking our bad common English, and I think it could be a possibility how to yeah, to facilitate.
Because
these
sometimes you
procedures.
feel like you work in a tower of Babel, you know. The Spanish judges too. It just depends, because everyone works in their own procedure, and they write to Austrian courts what they would write to the court in Sevilla. Yeah.
And the civilian have, of course, a different procedure. So it's really sometimes this cooperation maybe doesn't really work that much. And I think that's very important as well. Even we would prefer that we would meet here in person in Rijeka, so we would get to know each other personally as well. But I think we have the details anyway, or you have our details. Yeah. And what we would like to add, so it's no problem just to send an email, and we can share as well our experiences. I can say this for all of you, of us, where we have discussed these days with you. So I think you can simply just send an email, and we will be happy to reply to you and to share our experiences or discuss or whatsoever. Okay, let's go on. It has been 6 months and you have not received an acknowledgement of receipt of an European order for payment in Germany and Romania. What are you going to do? This is again a question for a judge, because
we have a lot of, we have
he's
really
in charge.
Most of the problems we have with the European payment order is the service. Yeah. If you didn't hear a lot of time, if you send it to Germany, you just can try to ask the court in Germany, did you serve it, or you can, yeah. But if you didn't, if it's Romania, it's better you just try another service. Yeah, you can't wait. I don't know, 2 years, and what I found out, if you wait more than, I don't know, 6 months,
and you have not received, you haven't received reply.
We had a lot of problems with Malta now. Malta didn't, I don't know what they did with our
payment orders.
They but now the postal service works good. Yeah. At first we served it by the regulation of the service of the document, and it was really nothing happened. Nothing. Yeah. That's not true. They wrote us soon they want to have 50 euro for the service, because in some of the countries you have to pay. You have to pay in Malta 50 euros. You have to pay in France, I don't know, I think 160 euros or so. They send us 50 euros. We sent 50 euros, and that was it. We never heard of it again. So we started to send all these European payment orders per postal service, and it works. Then the Austrian postal service stopped taking letters to Malta. I don't know, maybe they had no more place in there. Then we had 3 months nothing. We couldn't serve to Malta, and now they opened it again, and we serve to Malta. I don't know. We have a lot of claims against internet gaming companies, which are all in Malta. A lot of payment orders. And now we are serving it by post, and we get an opposition soon. Yeah.
Mm-hmm. Okay. Must an application for a European order for payment opposition thereto be made using the standard forms? It's easy to use the standard forms. There is a specific form, which is as the form A, which is actually the form C, I think. So B is the opposition. It's probably the best to use simply these forms because you do not need to found your opposition. You simply file the opposition, and that's it. So it's quite, again, use the codes. Don't write an entire story.
But you have to, the application for European payment order, you have to use the Formula A. Yeah, that's what you have. For the opposition, you don't have. If it's clear for us that there's an opposition, if you write down, I don't want to pay and sign it, it's enough. But for the application, you need the formula.
You can do it in both ways.
Yeah.
But from an attorney's point of view, I would use the standard form because I would be sure that everything would be filled in. Because you never know, Martina, for instance, she is
Yeah, but you have to,
strict.
but you have to, for the application, you have to use it.
Yeah. No, for the opposition.
Yeah, but
you are maybe not so strict, but they might be other courts who are very strict, and they would say, no, you didn't use the form as well. For the opposition, it was not done on the same time, on the right time. It wasn't valid. So I would, from a lawyer's perspective, I would probably use the opposition as well in the form of the form which is provided for.
Okay, and you get sent the opposition form with the European payment order, so it's very easy just to take
Exactly.
and sign it.
The applicant's representative informs you that the competent authority in Poland refuses to enforce the enforceable copy of the European order for payment because it lacks the judge's signature and the court's stamps. This is again a question: how are you going to enforce directly on the basis of the formula, which is, or the decision of the European payment order?
When the payment order was invented, all the enforced judges or Rechtspfleger didn't know these forms, so they didn't want to
Use it.
use it, and they really refused to enforce. Yeah, now it's getting better, and the problem is that enforcement is really under national law. So the people, if someone sits there and I don't know, in the national law he wants to have a original sign, or he wants to have, I don't know, 7 stamps, he wants to have it on the European payment order too. Yeah. And you can go now as a lawyer and say, no, in the regulation it is told that you don't have to do it, but it's better if you want really you want to enforce these payment order, you just go to the judge in Austria or wherever and say, please sign it by hand, or please put some stamps on it, because if someone refuses to enforce it, it's useless for you. Yeah.
I mean, maybe I can
Yeah.
add something. You would ask for the enforcement. We'll touch upon this afternoon. You will not go with the decision of the European payment order to the enforcement court, but for the enforcement you need this appendix F and G, which is this certificate, this European certificate, which is actually the basis for the enforcement. So it's not that much this decision which is the final point in the European payment procedure, but for the enforcement, you will have this certificate, which will be then the basis for the enforcement procedure. And we have different practice. For instance, especially as well in Austria, up to amounts to 50,000 euros, you would not need to bring as well the award. You wouldn't need to file the award or attach the award to this certificate, but you can simply enforce on the basis of the certificate. However, we have one court in Austria, which is the court in Graz, and they don't trust anybody, which means that they always require not only the certificate, but you always have to provide as well the award. All other courts in Austria, which are courts where you can enforce, or where you are going to enforce awards, in the meantime, they understood how it works and so on. They would accept only the certificate, whereas Graz, they simply don't accept it. And then you have to add it as well. So for the enforcement procedure, it will not be the final decision of the European payment order, which will be the basis, but actually the certificate, which will be issued on the basis of the final decision of the European payment order.
Yeah,
Okay.
but lawyers do it, as you see. If a court says, I want to have this, you just have to do it.
I mean, it's always the question whether you want to go and produce a lot of costs, whether you want to discuss, whether you want what you want to do. Whether, of course, the purpose of the attorney is to get the money for the client as soon as possible. So if this only is a question for the signature, of course, I would ask the judge and please him, could you be so kind, just simply sign it and I would just hand it in. But our law office, for instance, because we have many these procedures, all of a sudden we said, no, we really need to teach it to the judges that it's not necessary. And then we started a campaign. And actually, whenever they requested additional information, additional certificates, additional awards, and so on, we started to send them the legal provisions and informing them, of course, in a polite way, that this is not necessary and they should rethink it over.
Yeah.
So in the meantime, I think it works quite, especially in the courts, which have to deal a lot with this cross-border aspect, except for Graz. Graz is something where we were not really successful with our campaign. All right. Let's go to the next question. The applicant, the limited company, has forgotten to tick the box whether its claim concerns matters relating to a consumer's contract in the application
form. Yeah.
What are you doing? The opponent is a stock exchange. Is this a reason for granting the applicant an opportunity to complete or to rectify its application?
It's a complicated question, but if you see it on the first side that there are two companies, is there any chance that will be a consumer case?
No, of course not.
Yeah. So if you see it on the first side, you just don't have to go and put some completing or rectifying opportunities. Yeah. But if you are a lawyer and if you get it, then just think maybe this judge is a little bit, I don't know, crazy, because it's clear, and just sign it and just do your process and send it back. Yeah.
Maybe just some reverse consumer aspects. Consumer cases are cases where on the one hand there is a consumer and the other hand there is somebody who is acting on behalf of his business. So it's not two companies interacting, but there is one company usually on one side and on the other side somebody who is not a company but a private person. All right. You do not know the amount of the court fees due to your application for a European order for payment in Romania. How would you fill in space number 9 of the standard form? Which attorney costs can you include in your application? I think we discussed this question already today. I mean, I usually using or requesting the fees because I'm admitted to the Austrian bar, so I would request the fees on the basis of the Austrian RATG, which is the law applicable to the Austrian attorney's fees. And we were taught today and we learned today that the courts are willing to accept these fees and to award them if they are not out of proportion.
We left question 10.
Okay. We skipped it.
Okay. Must an application
We discussed
No,
it.
we
It
have
was a-
another one. Does a German attorney or a German collection agency have to attach the mandate to the application?
Which means, do you have to attach the mandate to this application? This is very interesting because, like in Austria, attorneys, we simply rely or we just simply invoke the fact that we are attorneys, and we never need to produce the power of attorney in a civil procedure. We never need to attach it, except if the court doubts that we are not really, we do not have the
Yeah.
power to do so. Whereas, for instance, in Slovenia and especially in Croatia, this is the most important document in a civil procedure, is the power, and you always have to produce it. And if I'm informed correctly, originally, so you're not even allowed to produce a copy of the power of attorney, but you have to add and attach always the original of the power to the any file, whatever you request. This is a really a cultural difference.
Oh, that's really. But if it's a payment order, European payment order, when you do not need a lawyer, and you work as a lawyer, what do you do?
Nothing.
You have to send the mandate or not? Yeah? No, but if you have to do it for a client.
It depends. I will tell you how I'm dealing with this question. So if I have a European payment order, instance in Slovenia, I'm attaching the power of attorney because I'm afraid that the court would request to attach it. If I'm asking it, I'm filing a European payment order in Germany or in Austria, I never attach it.
Yeah. And you never have to in Austria.
You don't
for
have,
example.
you
You
don't
don't have.
But in Slovenia, for instance, if I'm filing it, I always attach because I know that this is the most important document, and I'm quite sure that they will ask for it. Yeah. They also ask if it has, yeah, they also give you the second chance to provide it. It's, yeah, they give you the second chance, but in order to avoid these periods and another 14 days and so on, so I just simply attach it.
Okay, because
But this is a very practical approach.
because in Austria there's a law, the IRAC or EURAC, where all of European lawyers don't have to attach their mandate. So yeah, that's very interesting. Yeah.
But because the legal systems are different, because in Austria it's sufficient, it was changed many years ago, and the attorneys, they simply just who are qualified as lawyers, of course, and members of the bar, they simply indicate and they simply say and state, yes, we are relying on our mandate, and that's it. They never need to produce it.
And it depends on national law. Yeah, that's a, yeah. And the answer is no, and the answer is it depends on national law.
But
The answer is no. Yeah. And if a German collection agency does this, now sometimes collection, I found out that a collection agency in Germany are allowed to
file claims. In Austria, they are not.
They are not.
This is the fundamental difference, especially if it comes to the collection of debt. In Austria, so if you engage in a collection agency, then this is like anybody, like as you would yourself write letters and asking for the reminder letters, asking for payment. Because if it comes to a court procedure, because the debtor is not paying on the basis of the request from the collection agency, the collection agency is usually handing in or giving the case to an attorney. So they can never go themselves to court representing the case in the court. But this is just like a company for the collection of money, and that's it. So this is something which is maybe useful to know. And maybe something for the collection in general, the national procedures. It's very often the question which I'm getting from clients: how many reminders do I have to send to the debtor? Do I have to send one reminder? Do I have send three reminders? How many time must be in between the reminders, and so on? There is no fixed rule on this, so it's actually you're just sending one reminder. But of course, if you're polite, sometimes it can happen that the debtor just simply forgets about it. Then you of course send another reminder. But you don't need to send 5, 10, or how many reminders. This is one thing. The other thing is that the reminder, the question is how long must be the period between the reminder and how long should be the periods you're granting the debtor for payment. I know that the periods, especially in Slovenia, they are very short, and they always ask the payment within 3 days. In Austria, if you would ask somebody for payment within 3 days or within 8 days, everybody would say something is not okay with you. It's quite common, at least 14 days. 14 days. So this is something which is different. But then when the debtor still would not pay on the basis of your reminders, and the case would go and you would engage an attorney, the attorney, no matter which procedure he would choose, whether the national procedure, European payment order, or whatsoever, he will always send an additional qualified reminder as an attorney. Why is this important? Because if the attorney is not sending this qualified reminder and the debtor accepts and recognizes the outstanding amount in the first hearing, then the claimant would have to bear the costs. So this might or can have a consequence with respect to the costs, the procedural costs, the court fees, and the attorney's fee. That's why the attorneys, prior starting or filing the claim, no matter what kind of procedure they are deciding to choose, would always send a qualified reminder. And no matter how many reminders you have sent yourself to your debtor.
And then in the procedure, that's the big question: is this qualified reminder, has the defendant to pay this qualified reminder, yes or no?
It's always a big discussion.
Because the judges say in the rates of the claim, no, in the rates of in the cost of the lawyer, this is included. They have, it's simply said, they have to write one qualified letter that this is included. And now sometimes there are special agreements between the companies and their and where they write if you don't pay your debt within 14 days, you have to pay these qualified letter of the lawyer. You have to pay the interest and the qualified letter of the lawyer, and so the lawyers get their money extra. And we have a lot of the collection agencies now, and from my view, the costs are very high.
Too much.
I mean, they're very, very high, and the debtor has to pay the costs of the collection agency. There's a regulation, an Austrian regulation, which limits the costs, but they are really, really high. It's much. It would be much better just to go to court or to find a lawyer and go to court. But if they go to collection agency, and when with small claims, it's really, really,
it's a waste of time and money, actually.
And for the debtor, it's really, really a lot of
getting
costs.
expensive.
And more expensive.
I mean, maybe as you touched upon the question of costs in Austria, the lawyers' fees. Once are the fee arrangements. If you have deals and so on, this is a different thing. But as soon as it comes to court procedures, we have this law which stipulates, and basically you invoice only the written products, let's say it like this, the products or the submissions to the court. So you invoice the claim or the opposition to this claim, and everything which was done before is of course a substance or is included in this amount which you get for this claim. And this, especially if you have a lot of phone calls and you have a lot of meetings, you have a preparation meetings for the hearing and so on. This is everything included actually in the different amounts which you can charge. And you can charge in Austria, we don't have for the procedure one entire amount, but we have, for instance, we can charge, of course, the claim, then one submission, a preparatory submission, if really necessary too, but this is an exemption, and then the hearing. And then the hearing, it depends how many hearings were necessary and how long they lasted, and that's it, what you can. No matter.
And it depends on the amount. Yeah, it's
on the value.
On the value, yeah. It's
so the fees, the attorney's fees is due to the value of the case, of the claim.
so.
All right.
Now we come back to our German collection agency. Do they have to attach their mandate? At first, can they be
Be a representative?
and representative? What do you think?
I would say they can be a representative. They can represent, but they have to attach the mandate.
Because you
They
don't
have
need a
not-
lawyer, but you have to attach. Everyone can be a representative because you don't need a lawyer for these.
Qualified lawyer attorney.
Yeah.
Only the attorneys who are qualified and who are members of the bars who are entitled to represent clients at the courts in Austria, they don't need to attach to prove it, but it's deemed that they are working only if they really have a mandate, that they are not doing it out for fun. And moreover, they are of course also liable for their advices. They are advice.
Okay, the last questions. If you could choose, which procedure would you opt for? Now we heard you had both were introduced.
It depends. I think because it's not only the European procedures which you have, you also have these European possibilities, the European payment order, the small a small procedure for a small claims procedure has to be considered as an additional existing national procedures, because if, for instance, if to have, I don't know, witnesses, expert witnesses, and so on, then maybe it's wise to go straight to the national procedures. Whereas if there is just an invoice and I'm just claiming a small amount in another European country, procedure is the correct one. So it's, in my view, it's depending very much to claim how the situation is, what the situation with the proofs are, what would be necessary. And I usually try to decide when I try to propose which option I would choose. But
yeah, I mean, it depends. If you are sure you get an opposition, yeah, maybe it's better you just begin with the national procedure. It has no meaning to if you have only 5,000 euros, but if it's more, I wouldn't try a payment order if I'm really sure there's an opposition. Yeah. And if you could choose, if I could choose, if I take a small claims procedure, a payment order. Yeah, but
it
maybe
depends. I think it depends always on the individual case and the circumstances of the cases. But what I think is important is that you just simply consider this as an additional opportunity for the national procedures, and then you have to decide anyway in each individual case what to do.
Yeah,
All right.
and our last question, which standard forms do you think is easier to fill out? You don't have to answer.
I'm not
You-
going to
You are
answer.
waiting. If someone wants to answer somewhere.
We would appreciate any comments from our audience. Okay.
Yeah.
We just heard that the European small claims procedure was easier with batch.
Yeah, I mean, on their computers, what do they think?
I just see the name of Vladka, so maybe Vladka can give a comment.
She's not there
She's
anymore.
not there.
Ich bin da.
Yeah, Vladka, what would you say?
Well, I think that if you are a creation lawyer,
Yeah.
and there is somebody in Austria that is owning your money, it's simply easier to start with the formula, because as creation lawyer you actually cannot sue in front of Austrian court if you are not niedergelassen. So in that case you really have to look for some Austrian lawyer, some office that can support you. In that case, you're not representing your client by yourself. So you're actually giving your client forward, so to say. So I think that for every lawyer that's not sitting in the country, it's easier to take the formula, fill it out, and wait to see what's going to happen.
But have you had experience already? Have you?
I actually do a lot of inheritance law and family. I do a lot of family law and inheritance law actually.
Okay.
But I saw these cases, and actually the client came a little bit too late to me, because they did receive from the court in Vienna, the defendant gave his defense, and they didn't act in the period of, I think, 30 days. So they just put it somewhere in the table, and they didn't react. And then they came and asked, what should we do now? And I said, I don't know. I think it's too late. So they filled the form, they sent it, and they didn't react on time.
Okay.
And it was a payment sorry, it was a payment order, small claims procedure.
Yeah. I don't know. It was the payment order, yeah. And another case.
Yeah.
Another
they
case
didn't
was
act within 30 days. What do you mean with that?
I don't remember. That was 2 years ago. The Gläubiger, so the party, also die haben sich geäußert. Das wurde denen geschickt. Und die haben dann eine Frist bekommen, um sich zu äußern, und das haben sie nicht gemacht.
Ja.
Und damit war das Verfahren sozusagen beendet. Ne?
Ja.
Die haben einfach versäumt. Die haben einfach versäumt, weiter zu tun.
Yeah, but that's good, because that's the way the payment order really works good. When there's no opposition, you have a title. You can go to enforcement very soon.
And another case that I had was actually that was normal consumer claim in front of Graz court, and the lawyers from Croatia gave the response, and it was sent back to them asking that they do it either electronically or they should look for support of some Austrian lawyer. So actually we are again at the same problem. As Croatian lawyer, you cannot even give you cannot participate in the procedure, in the civil procedure at the Austrian law court, because you don't have access to electronical system.
Yeah, but the problem is for all lawyers from other countries, that is very hard to work in a procedure of another country. Yeah?
Of course,
Sometimes we have German lawyers who want to be in Austrian courts, and even if the language is not the problem, there are big problems. There are big problems and the procedures are not so far.
Is ZPO a problem?
Yeah, but really they write other. It just look they write other.
The different style,
Yeah.
everything is different.
Yeah.
Yeah.
Yeah, no, it's okay. That's it. That is how it works. It's just what I think
A
that.
comment.
Yeah.
But it is
it's-
like this. It is definitely like this
Yeah.
because if you do not have, and this program is quite expensive. So
Yeah, you have to really
You
have
will-
a lot of cases to have this.
you have to deal with it on a daily basis.
On the
Otherwise,
daily
it makes no
basis.
sense just from time to time. But maybe this is something which the European Union will also improve. Court of Justice. It's very easy. You simply register and you can hand in whatever you want. So maybe they will also approach this issue, and in 10 years we'll have a common program within all Europe, and we will deal and work with courts hand in and whatsoever with the same program. Okay, thank you, Vladka. So next time, if you're
Thank you.
working in Graz and issues, welcome, very welcome. Any other comments from somebody?
Or questions?
Or questions, or yeah. Okay, it seems
Okay, then we are ready.
If
Thank you for
we have
listening.
finished. Thank you to our comments. Thank you for having shared as well your for both of us. Yeah, as I said, you to exchange
If there are
experience,
questions,
if there are
just send an
questions,
email.
comments, whatever. We are both on the internet, our emails. Otherwise, my email is office@gvs3.at. You just simply put my name in the Google, and I will show up. And the same goes for
It's
Martina.
yeah,
So, thank you very much for your attention, and I'll give back to Daniel.
Okay, I would like to thank our speakers and attorney at law, Dr. Maria Shkov. And I would like to encourage everyone who is following us online, or a comment, or if you wish to present your own experience, you can use this time of a break to think of a question or a comment. And we will proceed at 12. Stay with us until the end of yes. Okay, so after the break, we will proceed with introduction to Austrian enforcement proceedings. As attorney Maria, some practical enforcement cases, which I think will be interesting from Croatia as well. Okay. To be enforced in Austria, so cross-border enforcement. Okay, thank you. And we will see each other after the break.
There it goes.
Okay, hello everyone. So we will proceed with the afternoon session and the last session of this seminar, which is dedicated to issues of enforcement. And my dear colleague Philip Ansberger, Associate Professor from University of Graz, which is our partnering institution on this project, Train to Enforce, will present Austrian enforcement proceedings. So Philip, the floor is yours.
Thank you very much, Daniela. Dear ladies and gentlemen, my name is Philip Anzenberger. I work at the Institute for Civil Procedure Law and Insolvency Law at the University of Graz. And thank you so much for this great organization. Thank you so much for having us. We are so glad to come here to Rijeka. And yeah, so the idea was, after discussing the European small claims procedure and the European enforcement order, to give you some small insight on how enforcement works in Austria. We now have, again, a theoretical input from my part. And then I think, Maria, you're gonna take over and give some practical input for at the very end. She's gonna do that, she says. Okay, perfect. So let me just share, hold on. I think it should now work, and you can see my slides. Yeah, so let me give you some theoretical input on the enforcement procedure in Austria. What are the legal sources? We have the main legal source for enforcement law, which is the Austrian Exekutionsordnung, the Execution Code. We also have some provisions in the Civil Procedure Code, the Jurisdiction Act, the Court Organization Act, the Act on Judicial Officers, and the Land Evaluation Act. The Austrian Execution Code actually entered into force in 1896, together with the Civil Procedure Law written by Franz Klein, as some of you may know. And it was in force mostly without any changes for a very large period of time. At the end of the 20th century, however, there were some important reforms, starting with a large rework on the enforcement out of claims, then of tangible movables, and the introduction of a simplified procedure for the issue of an enforcement order. We're going to hear about that a little later. In 2000, there was a redraft of the enforcement out of immovable property. In 2008, a rework of the forced administration of immovable property. And just a couple of months ago, we had again a huge rework of the enforcement code. We had significant changes to the enforcement out of other property rights and to the modalities for enforcement out of claims and out of tangible movables. We're going to go through that in a minute. Just let me start, though, with some basic ideas of the dogmatic framework of the Austrian system of enforcement. So the enforcement procedure is initiated at the courts and is carried out by the courts. So the courts in Austria do have a very central role in enforcement proceedings. What is the reasoning behind that? Well, our legislator said that it is appropriate that this is done, the enforcement is done by state officials, so that everyone can see that it's not private persons who act as empowered representatives. And that is interesting because, as we all know, there are some jurisdictions where this is quite different, like in France or in the Netherlands. But in Austria, it's just the courts who are responsible for enforcement proceedings. And the underlying idea is that the general purpose of civil procedure is that the conflict between people, between parties, is a social problem, and the civil procedure, and that includes the enforcement law, is a means of social welfare to solve these conflicts in a fast and efficient way. So this is our understanding of civil procedure law and enforcement law. So especially in enforcement law, we have various people who are involved, and the individual steps of enforcement are distributed amongst various court members. The probably most important court members in this area of law are the judicial officers. They have, or they're competent for several standardized types of enforcement procedures, such as, for example, the process and out of claims, and those are the most important enforcement procedures by far in Austria. The judges are only needed here for the more complicated matters. That would be, for example, a forced sale of immovable property or the declaration and confirmation of enforceability of foreign decisions. Also something that might interest you, even though it's the titles that we discussed in the last couple of enforceable. And then we have the court bailiffs, and the court bailiffs do set factual enforcement acts. For example, the seizure and the sale of a flat, a house, etc. So let me give you some basic ideas of the procedural principles in Austrian enforcement law. Parties, which will probably not surprise you. That means that the court is not working ex officio. Instead, the parties have to try to obtain an enforcement order and get the enforcement proceedings going. We have the weakened inquisitorial principle, and that means that whenever there is an open question in enforcement proceedings, which normally does not happen, but there is a chance that this happens, the court can actually go and do so, and can also take evidence on its own if it needs to do so. Proceeding, and that means that once the enforcement proceeding started, do not need to, or mostly of everything, there's exceptions for that, but generally the court takes care of the enforcement proceedings. So enforcement proceedings are started on application. They are not public, with obviously the exception of auctions, where we do want public to sell the things that best an economic way in order to enable an efficient satisfaction of the creditors. And where there's where the enforcement is about money claims, we also have the very important priority principle: be satisfied first. Generally, enforcement proceedings are written proceedings, but there's no strict principle of written for enforcement can be filed orally at the court. And if the court needs some factual knowledge, there is also the option of oral examination by the court. And we have some important provisions on the protection of the debtor. There are items and claims immune from seizure, and there are several restrictions regarding the seizure of claims in order to protect most necessary means, financial means he needs for his daily life. So that's about the theoretical or the dogmatic framework. Let's take a deeper look at the conduct of enforcement. So the most important thing to know is that the enforcement procedure in Austria is split into two parts. We first have a procedure, and once this order for enforcement is obtained, there is the actual enforcement proceeding, and that includes the seizure of the object, the realization of the value of the asset, and also the satisfaction of the creditor when the enforcement of money claims is involved. And so the creditor, first of all, needs to produce an enforcement title. And this enforcement title also needs to be needs to have a confirmation of enforceability. And if it's a foreign enforcement title, there generally again needs to be a declaration of enforceability. However, for many European instruments, this is not needed anymore, since we have the general abolition of exequatur in Brussels 1A, and we have several additional instruments that do not require a declaration of enforceability anymore. So within Europe, this is much simpler nowadays. If you want to know what enforcement or what acts, what documents are enforcement title, and there is a complete list of all the enforcement titles or unofficial bodies. That would, for example, be judgment, be resolutions from criminal courts, administrative resolution, etc., etc. So there's a variety of possible enforcement. If you have an enforcement title, is that you need a confirmation of enforceability. And that is the certificate that the enforcement title is. That means that the enforceable instrument, the enforcement title, has come by service to the debtor, and there's no more legal remedy with a suspensory effect, and the time has expired, which is not necessarily the same time frame. Sometimes they can vary. The enforcement title, who has also to issue this confirmation of enforceability. So basically, a creditor who obtained a judgment from an Austrian court would, after the expiration of the time frame for raising a legal remedy and for complying with the enforcement instrument, would have again to go to the court to issue the judgment to ask for a confirmation of an enforceability. And they get this by just the judge putting a stamp on the judgment, and then you can go to the enforcement court to apply for enforcement order. Case, ladies and gentlemen, most time the case. If you have a foreign enforceable instrument, you might need a declaration of enforceability. Because legal instruments that come from another country need to be recognized and declared enforceable before they can be enforced in Austria. And that happens according to European law. And this would be the case for Croatian and for Croatia and Austria, for example, but could also happen according to bi or multilateral treaties or even Austrian national law. Generally, the requirements are in the state of origin. This, by the way, is also always a requirement for enforcing titles from other European member states. They always need to be enforceable in the member state of origin. And the reciprocity of enforcement, which is also always the case within Europe. So these requirements within Europe are generally met. Step by step in the European Union, this so-called exequatur procedure was abolished, and the last big step was the recast of Brussels 1A regulation, where for any title that falls within Brussels 1A, we do not need a declaration. Anyways, the titles we were talking about here the last, like today and yesterday, they do not need an exequatur procedure. They can be enforced directly. So this is true for the European Small Claims Procedure and for European payment orders. Now, once the confirmation and possibly a declaration of enforceability, what he or she wants to do next is get an order for enforcement. And how can the creditor do that? Well, here she applies at the competent court, which we will hear a little later is always a district court. The question is more or less, where is the district court located? So the creditor files an application to obtain an order for enforcement. What does the court have to do? The requirements for enforcement are met, and if the application is objectively founded, and that basically means there is an identity between the parties in the title and the parties in the application, and that the application for an enforcement order is sufficiently determined to carry out the enforcement. If the procedural requirements are not met, well, there is a dismissal on the of the application as inadmissible. If there is a lack of objective foundation, the court dismisses the application on the merits. However, and this is a general principle in Austrian civil procedure law, the court, whenever there's a formal problem, has to give, I mean, there might be some exceptions, but generally it's like this. The court has to give the party the option to correct the mistake that was made. And this is also true in enforcement procedure. If the parties are not happy with the resolution, because this order for enforcement has the legal nature of a court resolution, there is always the legal remedy of a so-called recourse. However, it's possible that if you're the debtor, you do not get this court resolution before the actual execution happens. Because of the surprise effect, it is possible that at the very moment the court bailiff steps into your house, they also serve you the court resolution. Yeah, there's an important fact to know is that there is a simplified procedure to obtain an order for enforcement where the money claim is below 50,000 euros and the creditor cannot enforcement out of a movable property, or does not need to produce documents other than the enforceable instrument, or the instrument is a foreign enforceable instrument that still needs to be declared enforceable. And in these cases, there is the creditor needs procedure to get an order for enforcement. And what is the special simplification of this procedure? Well, the creditor does not need to produce the actual enforcement title. He or she just has to name the day of the issue of the confirmation of enforceability. And why is that so important? Well, in Austria, we have the so-called ERV, elektronischer Rechtsverkehr, and that is a system of electronic legal communication. And so if you need to produce an actual, and this is using this system of legal communication is nowadays mandatory between attorneys and the court. And so if the enforcement title, that would not function electronically, and that's why the Austrian legislature decided to create the simplified procedure where the enforcement title. But since there is, of course, the possibility of abuse, right? Because you don't have to produce the actual judgment or the actual court settlement. We have now an additional legal remedy called objection and an Einspruch. And creditor does not hold the enforcement title. Not correct. It does not match the one in the enforcement title. Okay. His or her enforcement order. The second big part of enforcement procedure can start, which is the carrying out of the actual enforcement. Types of enforcement procedures. Money claims can be enforced by the means of tangible movables, out of claims, and out of other assets. Assets that would be companies or intellectual property rights or shareholder rights, etc. Have very diverse provisions, for example, for the distribution of movable assets, for eviction, for granting or sending mandatory injunctions or prohibitory injunctions. Enforcement procedure is always carried out by the district courts. So the lowest level district and the local jurisdiction is always determined by the debtor's domicile or habitual residence. This was also changed recently. Before it was maybe not super complicated, but a little more complicated. Now it is always the debtor's domicile and habitual residence, unless immovable. Always the place of the immovable property. Where the district court. Immovable property lies. Yeah, so let's have a If you like, I would like to start with the enforcement out of immovable property. We have three subtypes of this enforcement. The first would be granting the registration of a charge on the property, so that if a property is sold, the creditor is satisfied first. Then we have forced administration. In any case, the enforcement order needs to be entered into the Austrian land register. And if the creditor applies for forced administration, well, the court appoints an administrator who takes care of the of the immovable property and tries to make money out of it by the accounting and distribute the surpluses to the creditors. If the creditor applies for a forced sale of the property, well, the court will appoint an expert to appraise conditions shall be set and made public by an edict, so that everybody can see that this is going to happen. The auction is judge. This is one of the few things that are done by judges in Austrian enforcement law. The lowest valid bid is half of the estimated value of the real estate. This is to protect whoever bids most during the auction wins the auction and has to immediately deposit a security of 10% of the appraised value. And then the buyer has 2 months to pay the amount that was bidden. And which is interesting is that the risks are passed to the buyer at the moment of the fall of the hammer, but the property actually is handed over after all the requirements are met, which also means after the price is paid. So if you buy an immovable property at an auction, that means that the risk you bear, for example, it burns down to the ground, you bear it from, but it's not your property until you fully pay the amount. So once the amount is paid, the court schedules a hearing with the creditors and decides the distribution of the highest bid, right? Because there could be many creditors that claim different rights. And once the decision of the distribution becomes res judicata, the creditors can be satisfied and the land register is adjusted. That's in a nutshell how the enforcement out of immovable property works in Austria. This is not the most important type of enforcement procedure. The enforcement out of tangible movables and out of claims is by far more important. Let's start with the enforcement out of tangible movables. Here we have a competence of the judicial officers to authorize the enforcement and of the court bailiffs to seizure and realize those assets. So the court instructs the bailiff after authorizing the enforcement or giving the enforcement order, instructs the bailiff where and when to attempt the seizure. And the seizure is completed by just registering the assets in the seizure report of the court bailiff. So the court bailiff does not necessarily take the assets with him or places a stamp or a sticker or something on it. He can't do that. And that would have different legal effects. But the seizure happens just by registering the assets in the seizure report. However, it is possible to take the assets into custody if the creditor applies for that, if he sees the risk that those assets would get somehow mysteriously get lost or be moved away by the debtor. And the realization of those assets again happens in an open sale, but can also happen in an auction. And then the distribution of revenues largely follows the rule of enforcement out of immovable property, as I mentioned before. The enforcement out of claims is carried out by the judicial officers. And we have, so There are some complicated rules for special cases, but the vast majority of claims are enforced according to the rules on ordinary claims. There is also some special provisions for negotiable instruments or claims documented in the land register, but this is not something I want to talk about to you today. So once the judicial officer issues the enforcement order, he or she also issues a so-called double order. The double order contains, on the one hand, an order prohibiting payment, and this is sent to this third-party debtor, for example, the employer of the debtor, and the debtor himself is served with a freezing order. And there is the possibility, this is always an issue, and also in other countries, I think it's regulated quite differently, so this might be interesting for you. If the creditor doesn't know who the third-party debtor is, he can just provide the debtor's date of birth in the application to obtain an enforcement order. And now the court requests from the main association of Social Security to find out whether the debtor is employed somewhere. And if the creditor does not have the date of birth of the debtor, which is also possible, well, then the register office has to provide that information if the creditor produces the enforceable instrument there. So you can actually get the date of birth of the debtor, and with the date of birth, you can go to the Social Security, or basically the court does that, goes to the main Social Security association, and they say if there is some working contract somewhere and who the employer is. Yeah, once the employer receives the order prohibiting payment, the third-party debtor shall give a declaration on all the facts of interest regarding the existence of a claim and also the probability of actual satisfaction of the creditor. Why? Because it's possible that there's already 5 other creditors sitting on this claim, and it's not likely that there will be any satisfaction with the next couple of months or even years. So there should be a declaration of the third-party debtor. Yeah, and how does the realization of the claim work? The practically most relevant way is the assignment for the purposes of enforcement. And that means that the creditor may demand the claim from the third-party debtor as if it was his or her own claim. So if I'm the debtor, I can go to the employer or any other third-party debtor of my debtor and say, please, now you have to pay me, and they have to pay you as the debtor. And the actual claim is paid off in accordance with the actual payment of the third-party debtor. So every month when there is a payment, part of the claim of the creditor is paid off. So and now I wanna highlight the new developments in Austria, the so-called enforcement packages. This is only in force for the last 2 months. We had, as I mentioned before, a huge reform in Austria, and we now have 2 enforcement packages to increase the success rate of enforcement proceedings: the so-called simple enforcement package and the extended enforcement package. The simple enforcement package means basically that you apply for enforcement out of claims and out of tangible movables at the same time. And in principle, the enforcement proceeding shall go on until the claim has been brought in or until the enforcement proceedings have been discontinued. And if no assets were found or identified, or if no claims could be satisfied, the proceedings shall be suspended, generally for 6 months. Now, if this simple enforcement package was unsuccessful, or if the claim to be recovered exceeds 10,000 euros, then there is a possibility for an extended enforcement package. And this covers the enforcement out of claims, out of tangible movables, and out of other assets like companies, intellectual property, etc. And now for this purpose, the court shall actually appoint an administrator who shall determine the assets of the debtor, who can perform acts of seizure and realize the asset, and shall also prepare a distribution draft and enforce it. And so basically, it's like a small insolvency procedure, if you like. So this is actually very close to what we have in Austria, or to the rules we have in Austria for an insolvency procedure. The dogmatic background might be a little different, but I'm not going into that here any further. So as a last point, I would like to go through with you through the security measures in Austria. We have two different security measures in Austrian civil procedure law. One would be asset freezing as a stage in the enforcement process, the so-called Sicherung or security execution, if you like, Sicherungsexekution or Sicherstellungsexekution. And the other would be the classical interim measures. So how does the asset freezing work? If a creditor has already obtained an instrument related to a money claim, but the title has not become res judicata yet, there can be this asset freezing as a stage in the enforcement proceedings. The requirement is an objective endangerment of the creditor's satisfaction. So the creditor has to prove that the enforcement of his claim would be significantly more difficult or even rendered impossible, or would have to be enforced in a country where enforcement is not assured by European or international law. Now, the creditor cannot obtain full satisfaction by this type of security measure. It's just a seizure phase. And as soon as the title becomes enforceable, not necessarily enters into res judicata. This is not in Austria, not necessarily the same moment. In most cases, yes, but there are moments where it's not the same. So as soon as the title becomes enforceable, the asset freezing measure automatically transforms into enforcement for satisfaction of the creditor. And if asset freezing as a stage in the enforcement proceeding is admissible, the creditor cannot apply for an interim measure on this with the same goal. And then we have interim measures. Interim measures are issued in a summary procedure and secure the process of the main procedure. They can be issued and enforced even before the commencement of the main procedure, but also during the main procedure. And there are three archetypes, if you like. There are measures to secure a money claim, there are measures to secure a non-money claim, and also measures to secure a right or a legal relationship. The applying party, who's called the endangered party, needs to assert and to prove the existence of the claim or the right or legal relationship, and an interest in issuing an interim measure. That could be the danger of not being satisfied, or the necessity to prevent imminent violence or an irretrievable damage. What are the possible security measures? There's a wide variety of security measures. It really depends on what claim or right or legal relationship needs to be secured. That could be the custody of movable tangible assets, or any prohibition towards the opposite party to set some defined actions, or third-party prohibitions. Last point, the standard of proof here is significantly lowered in comparison to classic civil procedures. There is only a predominant likelihood the endangered party needs to prove that what he or she asserts is more likely than the opposite, so then it's not happening. Gentlemen, I'm actually done with my presentation. Thank you for your attention. If you have any questions, please just let me know and I will try to answer. I'm still here, so if you come up with any question, thank you. If you come up with anything, just let. I will pass the word to Maria Schkoff.
Yes, thank you, Philip. So we can move to the practical part of the enforcement proceedings. And I will give the floor to attorney at law, Dr. Maria Schkoff. If you think of a question, you can answer them during presentation or afterwards. Let's go back.
Still?
This is the one, right?
Yes. We are coming to our last section of our training, Train to Enforce in Europe. And as Philip already provided you to the theoretical insights with respect to enforcement, I wanted to add some practical aspects which might be of interest, especially if it comes to the enforcement of titles from it became so much easier when Croatia joined the European Union because and the Ex-Quatur and so on. At the end of the day, it was impossible to enforce judgments from one country in the other country. And this is history since Croatia joined the European Union, which means that in Croatia nor in Austria. And I think this is a really in the internal market when it comes to justice. So I'll focus my presentation on some aspects which we noticed in the case of cross-border enforcement, and I hope that these information will be of use for you as well. So first of all, if it comes to the cross-border enforcement, we have to divide. We have to see, first of all, what kind of claim is it? Was it an uncontested claim, or is uncontested claims? There is a specific European regulation which provides the procedures in relation to uncontested claims, and it's the regulation uncontested claims. Uncontested claims are claims where the opponent, the defendant, didn't say anything, where there was no contradictory procedure. This can be an order for payment by note. It can be an order to pay to. This is a specific possibility according to Austrian criminal law. So if you have civil and you became party or the one who caused these damages to you was prosecuted in a criminal procedure and you have suffered damages from this criminal offense, then you have actually this order to pay, and you can claim as well as on the basis of an uncontested claim, and it's considered an uncontested claim. Then of course the default judgments, non-contested claims or payments orders in general, and another very important thing, which is the notarial deed. I know a lot of contractual relations deed, especially if they have also included an immediate enforceability of this notarial deed. I know this is very common means, and the enforcement on the basis of a notarial deed, especially if it contains a clause on the immediate enforceability, would be considered an uncontested claim. And then, of course, the settlement. It's very interesting for Croatia that the ovrha na temelju vjerodostojne isprave, which is the the payment order on the basis of an invoice, which is a specific procedure in Croatia, is not considered an uncontested claim. This is a really big issue because it came also to the European Court of Justice in two very prominent cases, in the Pula parking case and in the Zulfi Karpašić case. There was the question whether this ovrha na temelju vjerodostojne isprave, whether this is an uncontested claim or not or contested claim. And the issue is, the problem in Croatia with this ovrha is that it's issued by the public notary. And the European Court of Justice had to decide whether the public notary in this and the European Court of Justice held no, the court, and as a consequence, this decision on the basis cannot be directly enforced with a confirmation on the basis of Regulation 805 through 2004. This is, I think, very important to know, that it would not be possible with this certificate to go to enforcement in Austria. If it's an uncontested claim, you can request the competent court, or in the case of a notarial, he will issue the certificate on the basis of the regulation. And this certificate is the most important document in the case of enforcement in Austria. So for a lawyer, when we receive the requests for enforcement in Austria, so this certificate is really the most important one, and it's the most important document, what is written in this certificate. So this is the basis actually in order to start or commence enforcement procedure. We have the second set, which is the contested claims. There we have another regulation which provides for the specific procedures. You receive on the basis, if it was a contested claim, you receive a certificate on the basis of another legal provision and another regulation. And again, this certificate is the basis for the enforcement procedures in Austria. Again, the issue with the ovrha na temelju vjerodostojne isprave is not even a contested claim. So they are not really issuing, as it is not contested, it should not be issued the certificate on the basis of Article 53 of the Regulation 1215 through 2012. However, the Slovenian court, they have this izvržba na osnovi vjerodostojne listine, which is the same. However, there is a difference. The competent institution is not a public notary as in Croatia, but it is in Slovenia, it's the court. And that's the reason that in Slovenia, the courts are issuing the certificate of the regulation. So in Slovenia, this mainly same procedure is the basic for obtaining the certificate for contested claims. Whereas in Croatia, as the European Court of Justice held, the one responsible for this procedure, for the procedure on the basis of the authentic document, it wouldn't be sufficient, not even to get the certificate on the basis of Article 53 of the Regulation 1215. So when you have received this certificate, you start the enforcement procedure. And as I already said, if the value of the enforcement is below 50,000 euro, you simply need this certificate. If the value is above 50,000 euro, then you have to produce as well the judgment with the translation. It's always questioned whether you need to produce or translate the entire judgment, or whether you just need to translate the executive part of the judgment. I would say it's definitely sufficient is if it's only the executive part. And as I said in the morning session, the Okrajno-Sodišče in Graz, the Bezirksgericht Graz, always requires as well the judgment, even though the value is below 50,000 euro. And on the basis of the regulation 44 through 2001, this was the old procedure where there was actually, in the meantime, I think all procedures are following regulation 1215. So I think it's much easier. Or I prepared for you some cases which I would like to touch upon, specific problems which we are facing when it comes to the enforcement of creation certificates in Austria. So the one issue or the one case which I prepared to you, these are all cases which we share with you in order to give you insights, what are the problems and maybe what you can avoid if you have similar cases. The one issue is the due date. So very often we have loan agreements which are concluded in the form of a Croatian notarial deed, which includes the clause on direct enforceability. And in addition, these notarial deeds are usually providing the clause that the debtor engages in repaying the debt in 150 monthly installments are 1,000 euro. If, however, the debtor delays with the payment of 2 subsequent monthly installments, the entire open problem with this clause when it comes to enforcement. The problem is that somebody, in this case, the public notary, who would issue a certificate on the basis of which we would commence enforcement procedure in Austria, has to provide in this certificate also that the entire amount is due. So the public notaries are not often, or sometimes they are reluctant in stipulating entire amount is due. So they are not reviewing and rechecking and saying, okay, it's indeed the fact that the debtor missed to pay subsequent monthly installments and consequently the entire open amount is due. But this is fundamental, because if we do not have provided it in this certificate, we are facing problems in Austria, and actually we cannot really start enforcement procedures for the entire amount, because we can start enforcement procedures only for the amounts which are already due. And if we have a loan agreement where it starts 150 monthly installments each month, starting from, I don't know, 2015, then the last would be somewhere in 2025, which means that they are not due yet if there was not this clause. And as a consequence, it's really important that it's provided for. We already faced problems with the court, the Austrian enforcement court. They simply did not accept it because they say, unfortunately, it's not due. So what shall we enforce, even though it was so? And therefore, this is something which I would kindly or would like to touch upon, and I would like to tell you that this is an issue and which you should maybe pay attention in order to avoid difficulties when it comes to enforcement. Then the second aspect, or the second thing which I would like to share with you, it's as well a practical case which we the Croatian award, the executive part of the Croatian award read as follows. I tried to translate it into English, but I must admit I read it in Croatian language and I read it in German language, and it took me really time to understand actually what was meant. And I'm sure when I'm going to read it, or when you are going to read it, I'm sure it will be difficult for you to understand what is meant, except maybe for the one who procedures. So anyway, the executive part of the award reads as follows. The respondent is obliged to pay to the claimant within 8 days the amount of 12 million kuna according to the average exchange rate of the E&S bank applicable on the day of payment. So this is quite clear. And then plus statutory delay interest from the 13th of June 2011 until the 31st of July 2015, based on the interest rate fixed by the Croatian National Bank, valid on the last day of the 6th monthly period prior the current 6-month period, increased for a discount rate of 8%, valid on the last day of the 6th monthly period prior the current 6th monthly period. This is the period from 13th June till the 13th July. And then starting from the 1st of August 2015 until the payment, this is the second period, an interest rate according to the interest rate stipulated for every 6-month period through increase of an average interest rate for loans which were granted for more than 1 year on non-financial commercial companies calculated from the referential period prior the actual 6-month period for 5%. So this is indeed, I've got the award with me. It was an award issued. I mean, these were standard awards because the interests were so, it was no clear provisions on interest. The interests were going up and down. They were changing a lot. So this was a standard award. So this was nothing which is like for the cases in the books, but this was really a standard award which we received very often when it came to the enforcement. But this is of course due to the fact that the interest rates or the interests were not, I mean, they are not, yeah, they were calculated on this really strange formulas. So, and this was an award of the Visoki Trgovački Sud Republike Hrvatske. So this was really an award. Now, the big problem is when you have, and of course we received, this was an award based on the regulation 44, and so received this certificate, and we went into an enforcement procedure in Austria. And the problem was because in the certificate there is a field where you actually have to state what is the executive part of the award. So what was awarded actually, and if the executive part of the award is so complicated as this one, no court really wants to say, okay, the payment of 12 million, but actually they have to include everything. And as a consequence, they just simply write, have a look in the attached award. Okay, so then you get this award, this executive part, and you have to start commence enforcement procedure in Austria. And in this case, I mean, we finally succeeded, but we had to actually prove to the Austrian court, which is the district court, which is the competent court, all the interest rate, how they developed in these periods, and the request was really long, but yeah, this is something which is causing in practice really problems. I hope this will be much better. I'm pretty sure with Croatia developing economically and very well, so I think this will be much better in future. But just bear in mind, if you have this kind of awards, it's really it's not easy. It's not easy to really draw also and to draft also an enforcement request. So this is something I wanted to share with you. And then I wanted to share and touch upon another question or another difference between Austrian and Croatian enforcement system or enforcement measures, which is the seizure of the Austrian bank account. I know in Croatia you have got the FINA and you have the register of the transaction accounts where you immediately see if at which bank a company has got bank accounts and which one you can freeze. In Austria, this is not the case. So if you want to go and freeze a bank account in Austria, you need to get these information from somebody else. I don't know, from any other information, but you will not find a publicly accessible register which would work and where we would get this information, because the bank information are really saint in Austria, and so you would not get this information. Whereas, for instance, especially in Slovenia and Croatia, you have got this information and they are very valuable information. So in Croatia and Slovenia, it's common to seize the bank account. And there is also another difference between Slovenia, Croatia, and Austria. In Austria, when you seize a bank account, you can seize only the amount which is in the moment of enforcement on the bank account. Whereas in your country, you are going to freeze the bank account, and everything which is coming to the bank account is going to the creditor. The bank accounts of companies are in the moment of the seizure. They are usually, I mean, the bank accounts of companies in Austria, I would say they do not have that much money on the bank accounts, and usually they are not in the plus, but they are in the minus area. So which means that it makes no sense to seize the bank account. It's just costs which it is producing, and especially as also to the fact because it's not freezed, and so you are only seizing the amount which is on the bank account in the moment of enforcement. And this is a really big difference, and that's why in Austria we hardly seize bank accounts. So we really try to go for other assets, movables or immovables, or claims toward third parties, or even sometimes you just simply use the enforcement procedure to force the debtor to pay. I'll tell you one story. I had one debtor. He was a hunter, a passionate hunter, and he had, of course, the hunting guns. So, and he was a debtor to somebody, but he didn't have a lot of money. So I knew this would be a difficult thing, and I thought, okay, so what can I seize actually? And then I simply decided, okay, I will seize his movables, I will seize his hunting guns. And by doing so, or why I did try to do so, is because if he's a passionate hunter, and if I'm going to seize his guns, which he really needs to go for hunting, I'm pretty sure that he will immediately pay the outstanding amount and everything will be fine. And that's how it worked at the end of the day. So sometimes as an attorney, if you are seizing or if you are collecting debt, you really have to be creative. In one case, I remember many years ago, we simply seized the military plans of the Republic of Austria, because the Republic of Austria had debts. And we simply seized them, and I can tell you, we received the money very, very quickly. So if you're in the enforcement, you really need to be creative. So it's not just to seize the things which are written there. These are general provisions, but you have to be really creative. So try to find something which is of importance to your debtor, and I'm pretty sure they will pay very quickly, and they will find the money to pay the debt. Another thing which I think we have talked on during these 2 days is that, in fact, if you request or if you need to enforce, or if your debtor has assets wherever in Europe, and this I think is a really big advantage, is that as well advantage of the European Union and advantage of the fact that the awards are tangible within the European Union, that you can enforce them in all countries. You can request from the court which issued the award this certificate in any language you want. So if you know that your debtor has assets in Austria, please require the certificate in German language, and you will receive it. So you don't need to get a translation. The Croatian court will issue this certificate in German language. The same goes for Italy, Slovenia, Spain, France, wherever. So this certificate is issued in all languages of the European Union, and this makes things, of course, much easier. But of course, as I said before, it's important that where it's provided for, what is actually what is the executive part of the award, that this is not just provided there, okay, please have a look in the award, but that it is specified, and very important, that due dates are specified, and in the case of notarial deed and directly enforceable notarial deeds, that it's also stated that it's what is actually due. Yes, there is a question.
You mind if I step in just one?
Yes.
Please stay there. I think just not next to you. So one thing that might be very interesting for you, and before mentioned that you need this confirmation of enforceability to enforce any title in Austria, and it is very likely that some countries do not know this instrument. This is a specific instrument in Austria. So these certificates, for example, within Brussels 1A, it would be the certificate according to Article 53 of the regulation. They replace this confirmation of enforceability because they provide actually all the information necessary that we would normally get from the confirmation of enforceability. So if you have a foreign enforcement title and you provide the certificate Maria just mentioned, then you have all the requirements needed to enforce it in Austria. Sorry for interrupting you. I just thought it might be of interest.
Yeah, I think that's important. Maybe sometimes it's not getting very clear, especially if we who are working in a praxis, we are just informing you, yeah, we need this certificate, but on the other hand, from a theoretical point of view, there are different aspects, and of course, actually it's everything put together, and that's the document which you need in order to enforce claims in Austria. Okay. Last but not least, we talked a lot about fees, about court fees and so on. And during these 2 days, we always touched upon, but I never gave you and never provided you insights on the costs which you are facing when it relates to enforcement in Austria. So on the last slides, I provided you some information on the costs which you have to face if it comes to enforcement procedures. So the Austrian law, there's a difference if you're going to say movables or immovables, and on the other hand as well, there is a difference on the value. So if the value is lower, of course, the costs for the attorneys is lower, whereas the court always gets the same amount. As you see, the court fee is never, no matter whether it's 7,000 euro or 30,000, it's always 164 euro as a court fee. And of course, in the case of immovables, there is a different fee. So this is just something to give you some information about the fees which you have to face according to the Austrian provisions. So this was the practical insights on enforcement. Just a couple of aspects which I wanted to touch upon, which in this relation between Croatia and Austria with enforcing foreign titles in Austria, and in particular with the aspects which we are facing very often. So maybe by exchanging our views and our concerns in this, avoid these problems in future. So this was from my side. If there are any questions, we are here. We are welcome to answer your questions. Otherwise, and I'd love to keep in touch with you. So all the best. Goodbye.